You don't adequately grapple with the obvious fact that this is a 6'2" biological male. Yes, transition aside, the transition didn't begin until age 51 or 52. By then, JJS had acquired all of the physical, biological size and strength advantages of being male. Those don't go away because there is a transition. On what planet does it make sense? On what planet does that person with that sexual offense history, with being biologically male and also 6'2", not pose a threat to the safety of female inmates? I don't understand how you could conclude that this person shows no risk of being an offender. Mr. Maddox, I'd like to start with you. In 2000, you worked for a group called ACORN, the Association of Community Organizations for Reform Now. It's a left-wing organization, an advocacy group mired in scandal over allegations of election interference, embezzlement, and other illicit activities. What were your responsibilities in that role when you worked for ACORN?
Good morning, Senator. I worked for ACORN approximately 23 years ago for a couple of months, and my role was primarily focused on the membership drive, where I visited and canvassed neighborhoods in Washington, D.C., recruiting members for the organization.
Did you ever participate in ACORN's voter registration drives?
You know, Senator, looking back, I'm not sure whether there was a voter registration component to recruiting members to the organization. I think that that's possible. I don't specifically remember it. And I have to note that you mentioned the scandal earlier. It's my understanding that that scandal arose several years after my involvement in ACORN ended, and I did not witness any voter registration fraud and certainly didn't participate in any.
You were there in 2000 and left thereafter?
Correct, Senator.
Okay. Now, you stated in your bio that you'd been a member of the American Constitution Society starting in 2008. Is that correct?
As a law student, I was a member of the organization at Yale Law School. Yes, Senator.
Okay. Now, the American Constitution Society is advocating very strongly for what they characterize broadly as, quote, Supreme Court reform. If you go to the organization's website, it puts a little bit more detail on the matter. It says, quote, our Supreme Court is in a full-fledged legitimacy crisis. Put simply, we no longer have a Supreme Court that can be trusted to uphold constitutional rights, democratic principles, and judicial norms in this country. Close quote. Let's just pause right there. I've got more I want to read from that. Do you agree with that so far?
Senator, my involvement with ACS ended at the time that I graduated from law school, and I'm not aware of any positions that they've taken on this particular issue. But as a sitting judge, I'm bound to follow the precedent set by the Supreme Court, and I do so faithfully in my work, and I will continue to do so if I have the fortune of being confirmed for a district judgeship.
Do you agree with the assertion made in this statement that I just read to you?
Senator, as a sitting judge, I don't believe it would be appropriate for me to comment on that particular issue. That issue could be an issue that comes before me in my role as a judge, and I don't believe that it would be proper for me to comment on that.
Right. Well, I would certainly hope that as a sitting judge or as a judicial nominee to become a judge, you couldn't reach any comment other than to say, I disagree with it. I mean, this is calling into question the legitimacy of the court. It's saying that we no longer have a Supreme Court that can be trusted to uphold constitutional rights. Are you saying you take no position as to that and that you can't take any position as to that?
I was referring to any arguments that that organization may have to support the position that you've been describing. I can say that as a judge, I treat the Supreme Court's majority opinions as the law, as the state of the law. And I apply it in the cases where it applies. Any cases before me that come before me in my role as a judge, I apply relevant Supreme Court cases.
Why would it be asking too much for you to say, I disagree with ACS's characterization that the Supreme Court cannot be trusted to uphold constitutional rights?
I follow the Supreme Court in everything that I do, Senator. They set the Supreme law of the land, and I follow that law and apply it in my cases.
Even
as far as I'm concerned, the Supreme Court is a legitimate institution.
Okay. And an institution that can be trusted to uphold constitutional rights.
That's the institution that's charged with upholding constitutional rights, Senator, and I follow their direction.
Now, let me continue with the quote. It goes on to say, "This is the result of the right packing the Supreme Court and of the court's resulting conservative supermajority being driven by a staunchly partisan agenda that is increasingly hostile to fundamental rights and judicial norms," close quote. Let's unpack that one, and let's go to the first part of that sentence. This is the result of the right packing the Supreme Court. Do you agree with that characterization? Has anyone packed the Supreme Court in your lifetime?
I understand that the Supreme Court justices have been duly appointed to those positions. They were nominated by the president at the time of their appointment, and the Senate confirmed their nominations. And that's the process that each one of those justices underwent that got them to the Supreme Court, and that is the law. That law was followed in each of those instances.
And in fact, the number of justices on the Supreme Court has not changed in over 150 years. So, do you agree with the characterization that they have packed the Supreme Court, that anyone has packed the Supreme Court in your lifetime, in the last 100 years, in the last 150 years?
Again, Senator, I'm not familiar with the positions that this organization has taken on this particular issue.
I'm not sure. You that position. They said that the court's been packed.
But I'm really not sure what they mean by packed. I think that the persons who occupy the seats on the Supreme Court currently were duly appointed to those positions.
Okay, I'm out of time. Let me just finish with one thought here. They characterized the court at the end of that sentence as, quote, increasingly hostile to fundamental rights and judicial norms. Do you agree or disagree with that statement?
I would not agree with the statement that they have been hostile to fundamental rights, Senator.
Thank you. Thank you very much. Thanks to each of you for being here and for your willingness to serve. Ms. Mihalchik, I'd like to start with you, if that's all right. I want to talk about Lochner versus New York for a moment. Was that case correctly decided? And I'd love to know your reasoning as to why it was or was not correctly decided.
Senator, I believe that is still binding case law in
It's
our.
not.
I'm sorry, Senator.
Lochner versus New York.
Lochner versus New York.
Yeah,
No, so because that is no longer binding case law, I would stand by whatever the precedent of the Third Circuit and the Supreme Court is, and that is the appropriate standards and law to apply in any cases that come before me.
Yeah, that's why I chose this one, because it's dead precedent. It's not
Yes.
around anymore.
Correct.
If you remember, this is the case where the Supreme Court invalidated some minimum wage, maximum hour laws passed by the state of New York.
Yes, Senator.
Protecting bakery employees. You still feel you can't opine on that, even though it's dead?
Senator, I think that it would be inappropriate for me to opine on it in the sense that what is binding and appropriate for me to apply would be the binding precedent of the Third Circuit and the Supreme Court at this point.
Gotcha. It's unusual, and that's why I choose that case on occasion, is because it is dead letter. But so it's disappointing that you won't get into it. I hope you reconsider when I submit questions for the record. Ms. Garnett, let's go to you next, if possible. On July 10th, the U.S. Attorney's Office for the Southern District of New York, which is the office where you now work as special counsel, announced that it was bringing charges against Dr. Gall Luft, who claims that in 2019 he gave incriminating information about Hunter Biden to the Department of Justice. About this indictment, his indictment, Dr. Luft said, quote, "I volunteered to inform the U.S. government about a potential security breach and about compromising information about a man vying to be the next president, and I'm now being hunted by the very same people who I informed," close quote. Are those charges against Dr. Luft, are they retribution for his willingness to speak out about Biden family corruption?
No, Senator. Those charges were actually returned in the fall of last year. The indictment was returned in the fall of last year. Mr. Luft was arrested in, I believe, Cyprus, and he was bailed pending extradition, and he fled from his bail.
Would you agree that they could be perceived as retribution for blowing the whistle on Hunter Biden?
I suppose someone could make that accusation, Senator, but I don't believe it's accurate.
Do you think at least the timing of those charges, I mean, wasn't it on July 10th that the U.S. Attorney's Office announced that it was bringing those charges?
Actually, Senator, the charges were returned last fall. The indictment in the United States, I believe, was unsealed on July 10th. I had no involvement with that decision. The indictment was unsealed in the United States at that time because it was determined, if, as I understand it, that Mr. Luft had fled from his bail in Cyprus and was not likely to be rearrested.
They were returned then. When were the statements made to the government? The underlying statements, were they made in 2019?
I had no involvement with that, Senator, so I don't know the details.
Okay. Given the concerns you've expressed about whistleblowers in the past, aren't you concerned about this whistleblower and about the appearance or the perception that he might have been the victim of retribution here?
I understand that some folks have expressed that perception. I can tell you from my experience in the case last year that that is not accurate.
Okay. Ms. Wang, I'd like to ask you a couple questions, if that's all right. When you were a student at Cornell, you made a statement to the effect that, quote, one of the things I've run into in America is that people pay lip service to liberal causes, but still have deeply rooted prejudices. Is it fair to say that this is what you perceive about leftist hypocrisy, or what is it?
Senator,
Or poser leftists, or is it?
Senator, those statements were made during my time at Cornell as an undergraduate regarding anti-Asian bias incidents, hate crimes. And so it was efforts to get the administration to have an open dialogue and to acknowledge that there was violence against a particular group of students on campus.
Okay. Would you agree then that the consideration of race in college admissions, an issue that's recently been addressed by the Supreme Court of the United States, might be one of the causes that one could refer to that's on its face liberal, and yet it's deeply rooted in prejudice?
Senator, my personal views are irrelevant to my current standing before you, because as a judge, I would be a neutral arbiter, faithfully applying precedent and the text of the statute.
Okay. I'm out of time. It appears to me that sometimes the canons are being invoked a little bit excessively. We can talk about things, we can reason with things without weighing in on how you might rule as a judge. Thank you.
I'm going to be doing them this Friday in Connecticut. I love doing them. They give me hope and inspiration, especially as I get out of Washington from time to time. Thank you.
Thanks, Senator Blumenthal. Senator Lee.
Thank you, Mr. Chairman. Thanks to all of you for being here and for your willingness to be considered for these important positions. Judge Kasuba, I'd like to start with you, if that's all right. A few months ago, in May of this year, you gave a presentation to the Oregon State Bar in which you included the following in your remarks. Quote, DEI, diversity, equity, and inclusion, is the heart and soul of the court system. Can we say that? Yeah, I just did, and I say it proudly. Mr. Kasubai, Judge, could you explain what that means?
Yes. Access to justice is at the heart of the work that I do within the courtroom, and ensuring that everybody is dignified and treated with dignity when they come into the courtroom, and for me to preside over those cases.
But you'd say that's the heart and soul of the judicial system, more than equal justice under the law, more than the Constitution, more than the law itself, or the job of interpreting the law fairly, where litigants before you have disagreements as to the law's meaning.
In the way in which, and in the context in which I was using the term and referring to diversity, was the idea and the ideal of equal justice under the law, that everybody, no matter what their background, beliefs, whatever that might be, that everyone is entitled to access to the courts and that equity.
All right, let's circle back to that one in a minute. The First Amendment's protection of free speech is foundational. It's been described as one of our first freedoms. It's been described accurately, I think, fairly, by many as being upstream from all of our other rights. And it has to be protected vigorously. And we also know that, that there are time, place, and manner accommodations that can go along with that. Among other things, there are special exceptions that occur where riot control measures are necessary due to an outbreak of coordinated overt violence. In a case that's been referred to briefly in the hearing today, but not much, this Bucharata versus City of Eugene, you're dealing with some interesting circumstances. You had riots taking place. There were 3 nights of terror in Eugene, Oregon, during the BLM riots of 2020, where, in your words, the following was going on. Quote, a crowd applying graffiti, lighting fireworks, and blocking traffic, throwing glass bottles towards officers surrounding a patrol car, smashing its windows and puncturing its tires, with the officers inside the patrol car, mind you. The group, quote, started fires in the roadway, attacked people and vehicles in the downtown area. Several businesses were vandalized and looted, and several officers were injured. You went on to state that members of the group carried heavy backpacks and bottles and were communicating via radios. So in response to this, the city implemented some riot control measures. They imposed a citywide curfew, one that lasted 7 hours. We had 3 rioters who were arrested during the curfew, and despite the Ninth Circuit precedent in the Mariotti case, the Minotti case, addressing a very similar curfew in Seattle, you decided that the Eugene, Oregon curfew was unconstitutional. Can you explain to me how, consistent with the Ninth Circuit precedent in the Minotti case, how does a 7-hour curfew through the middle of the night in the wave of such destruction and terror prevent ample means of communication? Can you explain that to me?
The Minotti case did provide guidance and assisted me in evaluating the legal analysis that I applied. There were 2 curfews that had been imposed. One was a downtown curfew, so there were geographic restrictions. That was not the curfew that was before me, nor did I find that unconstitutional. It was a citywide curfew that actually subjected everybody in the city, well beyond the boundaries of downtown, to out into the residential neighborhood, such that the application of that curfew, that citywide curfew, could have criminalized people's behavior of just trying to get home, well outside of any of the riots and the protests.
You've praised Ibrahim X. Kendi as someone who you like, as an amazing historian and author, and you said that you would like to push some of Ibrahim X. Kendi's ideas even further. I'm sure you're aware he's famous for saying, quote, the only remedy to racist discrimination is anti-racist discrimination. The only remedy to past discrimination is present discrimination. The only remedy to present discrimination is future discrimination. Kendi also stated that in order to truly be an anti-racist, you have to be anti-capitalist. So I'd like to know, first of all, what would you do to push Ibrahim Kendi's ideas even further? And do you believe someone should be praising, someone who is currently a federal magistrate judge, be praising someone who encourages discrimination in any circumstance?
Senator, I don't recall having ever remarked that I want to push Ibrahim Kendi's ideas further. In questions earlier in this hearing, I clearly stated that the ideas that have been described here that have been attributed to Ibrahim Kendi are not ideas that are consistent with the 20 years in my public service, 16 as a judge, and the record that I have shown striving to apply the law, the Constitution, and Supreme Court precedent would not be consistent with this idea of supporting the ideas that you've described as Ibrahim Kendi's.
So you're saying that you have never said that you would like to push some of Ibrahim Kendi's ideas further?
So I don't recall having made that particular statement.
Okay. I see my time has expired. We'll follow up on these in writing. these are concerning one of the most fundamental laws we have that's embedded within our Constitution, is that governments can't treat people differently on the basis of their race, and that's why this is important to ask about. Thank you. Thank you, Mr. Chairman. Thanks to all of you for being here. Ms. Hill, I'd like to start with you, if that's all right. As you know, in 2020, in the McGirt case, the Supreme Court held that in unique circumstances, major crimes committed in Indian country can be prosecuted only by tribal or federal courts. This ruling removed the state's ability to prosecute those crimes in those circumstances. Now, you strongly support the McGirt decision, and it's important to keep in mind that in Oklahoma versus Castro Huertas in 2022, the Supreme Court clarified that states retain the authority to prosecute non-Indians who commit crimes against others, even if those crimes take place in Indian country. Now, in one of your many critiques of that decision, you called Castro Huertas, quote, a very negative decision. And you said that, quote, Kavanaugh's opinion, which of course was the opinion of the court, Kavanaugh's opinion, it was terrible. To justify that critique, you came up with a hypothetical in which you stated that, quote, a non-Indian steals a car from an Indian, and that person can be prosecuted by the state. That person can also be prosecuted by the United States. They can be convicted twice for the same act and serve 2 sentences. That was part of your critique. My concern is that your critique here demonstrates a fundamental misunderstanding of how the double jeopardy clause of the Fifth Amendment works. I think most first-year law students can tell you that double jeopardy prevents separate prosecutions for the same offense when those prosecutions are brought by the same sovereign. A non-Indian who steals a car from a non-Indian, for example, in Utah, is properly subject to prosecution by both state and federal authorities, by the state government and by the federal government, because they are separate sovereigns in our system, just as in any other state in the United States. State governments are unique. They are unique independent sovereigns, separate and apart from the federal government. And the federal government is a completely different sovereign. This has been a line of authority. This has been a principle that's been clearly established ever since our nation's inception, certainly ever since we adopted the double jeopardy clause in 1791 as part of our Constitution. So yes, McGirt presents a unique set of circumstances, an Indian committing a crime against an Indian in Indian country. But nothing in the Constitution prevents a state from prosecuting a non-Indian for their crimes, regardless of who the victim is. So in your view, do you disagree with the characterization of double jeopardy as I've just stated it? Do you disagree that the states are separate sovereigns from the federal government for purposes of the double jeopardy clause?
I certainly don't disagree with that.
And if confirmed, would you follow the majority opinion in Oklahoma v. Castro Huertas?
I absolutely would. And given the practice that I've had, I've been following it for some time.
Your apparent desire to remove the state's authority to prosecute non-Indian offenders would, in my view, only weaken law enforcement's ability to remove violent offenders from the streets. And it's dangerous to place loyalty to any particular group over your loyalty to long-established principles of law or of the Constitution. So am I misreading your statement regarding Castro Huertas or the hypothetical?
I think that the full context maybe is not really reflected there, the full context of my comments. I can say, certainly on behalf of my client, I was critical of the decision in Castro Huerta because it was a decision that had other ramifications in Indian law outside.
Right, but I'm not talking about the other ramifications. I'm just talking about about double jeopardy here.
Right, I understand that. But those ramifications, that was some of the context of my criticism of it. I certainly believe and understand that I'm required to will be required to follow the law if I'm so fortunate as to be confirmed to serve in the Northern District. And I understand the distinctions that if you have 3 sovereigns, that all 3 sovereigns could bring those claims, and there would not be a double jeopardy issue.
Okay. While you were while serving as Attorney General of the Cherokee Nation, did you state that you had no intent to enforce the law post-Dobbs?
I never said that.
Did you at any point say, I expect, and I think everyone expects, massive constitutional challenges to that law, just for your awareness, referring to those laws?
I was not referring to Dobbs. That was the decision of the court. I was talking about the Oklahoma law that had been passed relating to abortion post the decision in Dobbs, and that law was being challenged, had already been challenged in the courts. It was significantly newsworthy in Oklahoma at the time that the Oklahoma law was being challenged.
Challenged post-Dobbs on grounds that you believed were legitimate challenges post-Dobbs?
I couldn't say that they were legitimate. I just knew that there were likely to be many challenges to it. It was very contentious.
Okay. See, my time's expired. Thank you, Mr. Chairman. Thank you, Mr. Chairman. Thanks to all of you for being here. Mr. Leibowitz, I'd like to start with you. I assume you'd agree with me that the federal government is one of limited enumerated powers, correct?
That's correct, Senator Lee.
And to the extent that any one of the enumerated powers granted to Congress is limitless, then the 10th Amendment is meaningless, right? I mean, if Congress can do everything, then there's not much reserved for the states. A few years ago, you wrote a law review article criticizing the Supreme Court's opinion in United States versus Morrison. As you'll know, it's one of only 2 instances in which the Supreme Court has struck down a statute as being enacted in excess of Congress's authority under the Commerce Clause. It did so based on a conclusion that the activity regulated in that case, acts of violence, were non-economic in nature. They were bare intrastate, non-commercial activity occurring in one state at one time, not part of any interstate commercial transaction, and not part of any channel or instrumentality of interstate commerce. You derided that decision as an instance of conservative judicial activism. You also said that it was a problem. You strongly disagreed with it. Can you tell me if you disagreed with the holding in Morrison, and the holding specifically that the Commerce Clause power can't apply to bare, intrastate, non-commercial acts of violence in that instance, what remains beyond Congress's reach under the Commerce Clause?
Senator, I thank you for the question. As you know from the question, let me start with the article. The article was written in 2000. It was written after Morrison and after Lopez. Those were the first 2 decisions since 1937.
The only 2?
Yes, sir. Yes, Senator. The only 2 since 1937 where the court struck down acts of Congress as beyond the commerce power. Lopez in 1995 was a very important decision because it was the first one, and to supplement what you said, Senator, there were 3 grounds why they struck down Lopez. There was non-economic activity. There was, does it invade a traditional state function? There was, what are the findings of Congress? Well, in Morrison, so there were 3 reasons why they struck it down in Lopez. Morrison, viewed by everyone, whether you agreed with the decision or not, really relied on the first one because Congress made explicit findings, voluminous findings in Morrison. The statute itself that was struck down was a civil rights statute, a civil liability statute, not something traditionally reserved to the states. So although you used the word that I criticized with my co-author, Morrison, we really didn't.
Wait, you're saying acts of violence are not historically reserved, covered by state law? I mean, tort law?
Senator, you're certainly correct the way
criminal law?
Yes, Senator, you're certainly correct the way you just stated it. That is state law. But the Violence Against Women Act, the provision that was struck down, was a civil liability provision that was akin to civil rights laws that were passed by this body. Civil rights laws like cases that were upheld in Katzenbach versus McClung and others. My only point, Senator, is that I don't think it's fair to say that my co-author and I were criticizing Morrison. We wrote at a time.
Well, it's generally regarded as criticism when you call it an act of judicial conservative activism. That's not a compliment.
I don't think that phrase is in keeping with the article. What I would agree with you, Senator, in saying is that the Supreme Court in 1995 and the Supreme Court in 2000 started to get more formalist in their categories. And in 2005, after we wrote the article, in Gonzalez versus Raich, the court did not go that far. They did not continue on the path that we were talking about.
Yeah, but Gonzalez versus Raich involved a different category, involved something, exchange of a contraband item for which there's an established interstate commercial market. And therefore it couldn't be regulated adequately absent comprehensive control by national authority. That's very different. By contrast, here's what you said in the article. This is an excerpt from it. Quote, if the court finds that all federal regulations of non-economic activity are equally precluded from the Constitution's limitations on congressional power, then such a decision would so violate social expectations and needs that it would likely require the court to turn to a different approach in order to define commerce power in a way that's consistent with the four corners of the Constitution and the pressing needs of growing a national and international society. I'm not sure what that means. I'm not sure what provision of the Constitution allows us to modify the terms of the Constitution based on social expectations and needs, or on the pressing needs of a growing national and international society. Moreover, the minute you open up the Commerce Clause to being applicable to bare intrastate non-commercial activity outside the scope of civil rights legislation enacted in 1964, which just as easily could have been defended as an exercise of Section 5 of the 14th Amendment, you're in dangerous territory. NFIB versus Sebelius doesn't count because the court went on to rewrite the law not just once but twice in order to save it from an otherwise inevitable finding of unconstitutionality. I don't understand what your approach is. How would you have written Morrison?
Mr. Chair, if I'm allowed to answer, Senator, if I'm allowed to answer with the time, I appreciate the question. I think I would have said this. There's a lot in your question, Senator. Let me first assure you that there is nothing in that article that should give, I believe, any member of this committee any pause that I will follow the law. If Morrison's the law, I'll follow it.
Yeah, I'm not doubting that. I want to know the answer to my question.
Yes, sir. Yes, sir. So let me take that. And that's why I thought it was important that I said that we wrote it in 2001. After cases like Gonzalez versus Raich in 2005 and others, as you know, part of your question is that the court was seriously considering abandoning, Justice Thomas and others were thinking about abandoning the substantial effects test. That part of the Commerce Clause. I know, just having heard your question, Senator, that the substantial effects test bumps up against the 10th Amendment all the time. What I would say is...
But it swallows the 10th Amendment.
I take your...
But they didn't get rid of that. That's why I'm trying to understand what your analysis is here.
That's right. So what I would say is that after 2005 and other cases, the court has not abandoned the substantial effects test. And if I was so fortunate to be confirmed as a district court judge, I would follow what the Supreme Court and the 11th Circuit say. They allow, in certain cases, when evaluating acts of Congress, to determine whether they substantially affect interstate commerce. That is currently my understanding of the law, and I would follow it. But let me assure you, Senator, I think my background as an assistant United States attorney for 12 years, I think my background just as a lawyer in Miami, I don't think that you should have the, that your question, if it has a concern that I would be some roving judge that would take the commerce power and swallow the 10th Amendment whole, I would respectfully suggest that I would do nothing of the sort.
I get that. I just don't want somebody interpreting the Constitution based on growing societal needs instead of the text of the Constitution. Thank you. Thank you, Mr. Chairman. Thanks to both of you for being here. Ms. Berner, I'd like to start with you, if that's okay. In March of 2020, would have been just before the COVID pandemic, changed all sorts of things that year. You spoke at Rutgers at an event on economic justice. As part of your speech, you criticized the Republicans on this committee, comparing us to union busters. You stated as follows, and I quote, despite the fact that multiple women credibly accused Kavanaugh of having sexually assaulted them, Senate Republicans allowed only one woman to come forward to testify. They ignored or belittled the other accusers. The fact that Dr. Ford was only one person allowed Republicans to pretend the situation was he said, she said. And these techniques were taken directly from the playbook of anti-union employers during union organizing campaigns. Now, I assume that you would have thought it would be more fair to the parties to have a panel of any person inclined to throw accusations at then Judge, now Justice Kavanaugh. Is that correct? Is that what you were saying?
Senator, good morning. Thank you for your question. When I made that speech, I was speaking at Rutgers University in my capacity as General Counsel of the Service Employees International Union.
Right, but it was you speaking, right?
Yes, sir.
Yeah. So in response to my question, is that what you're saying? It would have been more fair to just put anybody up there willing to throw accusations at him?
Senator, I believe it falls to the members of this committee to decide and determine how judicial confirmation hearings take place. What I can tell you is that I believe Justice Kavanaugh, as every other justice of the Supreme Court, was legitimately confirmed. And were I to be so fortunate as to be confirmed, I would follow his opinions and the opinions of every justice.
Okay. I do take issue with your suggestion that we ignored or belittled anyone. I sit on this committee. I sat on this committee then. We went to great lengths to make sure that that we heard accusations. Now, would you consider a person's involvement in a system of covered-up sexual harassment something that should be disclosed in a nominations hearing?
Senator, the system for disclosure is quite lengthy. I know my colleague and I participated in lengthy reviews of our records and background investigations, and I trust the members of this committee to determine the appropriate process for review of nominees.
Now, your actions dealing with an SEIU sexual harassment scandal were outlined in an expose published by the Payday Report, a pro-labor website, in 2019. Whether or not you believe numerous women who accused the SEIU executives of sexual harassment, do you think it would have been important for you to disclose to this committee your involvement in that scandal?
Senator, I was general counsel. I was counsel to the Service Employees International Union at the time of the events that you are referencing. And as a lawyer for my client, I zealously advocated for my client in those matters as in every other matter.
Sure. Now, one of the women who was alleging to have been the victim of misconduct, sexual misconduct, by several of the men in leadership roles, in roles of significant authority within SEIU, including her SEIE UHW division director, who wrote a letter to which she responded. Now, in that letter, she begged you to come to a sworn deposition where she would be testifying. She would be providing sworn testimony about the alleged assaults against her by SEIU directors and executives so that you could reach your own conclusion as to whether there were problems within the union. Now, you responded, declining to attend or even investigate the matter, writing as follows, quote, "Because each local SEIU employs its own staff and sets its own personnel policies and protocols, the International Union does not have a direct role in investigating allegations or concerns that may arise in local unions regarding personnel matters." You also encouraged her to continue engaging with local staff. Primarily, what that meant was continuing to engage with the person she was accusing, with the guy she had accused of victimizing her. So why didn't you disclose your involvement in this issue, including and especially that part? I mean, that's not a realistic option, is it? To tell the victim, go talk to the person who's messing with you, who's harassing you, who's breaking the law. You didn't disclose that to the committee, did you?
Senator, I faithfully complied with all of the requests asked of me and required of me of disclosures. In my 25 years of practice of law, I have handled hundreds of matters, and I have done so zealously, as has been my professional obligation as an advocate. And I understand that sitting before you today, I am seeking a position as a neutral, and I would take the transition to that new position seriously and faithfully, And any position that I had taken in the past on behalf of a client would not influence any decision that I would make were I so fortunate as to be confirmed.
Dave Regan, who's still the president of that union, and still a vice president, he was one of the men most often accused, and he was allowed to use the union members' dues to defend himself. You think that was an appropriate use of the members' dues?
Senator, I am not counsel to the local union that you are referring to, and I'm not familiar with the facts that you referenced.
I see my time's expired. Thank you, Mr. Chairman. Thank you, Mr. Chairman. It's a pleasure to be here today, and I'm so grateful to President Biden for his willingness to nominate Judge Anne Marie McKiff Allen to the U.S. District Court for the District of Utah. I've known Judge Allen for 30 years. She and I were law school classmates. Judge Allen, even back then, had the perfect temperament for a judge, never drawing attention to herself, but always prepared. She had a steady, quiet, and always dignified approach, one that inspired respect from all of her classmates. We, over time, got to know Judge Allen's husband and soon came to realize that they were the power couple. You know, there are a small handful of people in law school who are married to another law student, but the Allens were the power couple of our law school. Randy was a year ahead of us, and we always went to Randy for sage, wise advice, which he always had. He's very smart. I told them at the time, it's almost not fair for the two of you to be married to each other. You're going to mess up the gene pool for everybody else's kids. And speaking of that gene pool, we're pleased here to have all three of the Allens' kids, and as well as the spouses of their two married kids. We've got Matthew and his wife, Louisa, and we've got Lauren and her husband, Will, and we have Eliza. And we're looking for that someone special out there someday. The Allens also apparently have more in common with Judge Rankin than I would have realized, because like Judge Rankin, Judge Allen has two children who have served as Senate pages. Lauren and Eliza were both here as pages. I was frankly kind of offended that Matthew never expressed interest, but we'll take that up for a different day. In any event, the Allens are here in full support. I've asked them to serve in the same role as Taylor Swift in the cheering section of a Chiefs game. That'll be sure to happen. Judge Allen brings a wealth of experience and background to this as a practicing lawyer, as someone who's served in the public and private sector, as someone who's been the general counsel of Southern Utah University, who's handled clients and matters in a wide range of civil, criminal, and family court matters, and as someone who brings a wealth of experience as a judge over the last few years. She is very well suited for this position, and if confirmed, will be filling a role that will be stationed in Southern Utah, our first full-time post for that position from the outset, being based in St. George, Utah. So it's without hesitation and with great pleasure that I introduce Judge Anne Marie McKiff Allen to this committee. Thank you. Judge Allen, getting back to Senator Durbin's original question, can you just confirm to the committee that I was a very mousy, wallflower, unopinionated, and afraid to express myself in law school?
Thank you, Senator. I wish I could do that.
It was worth a try. Worth a try.
Reminder that the witness is under oath.
You've been involved in, as a lawyer and as a judge, about 75 trials. Is that right?
Correct.
A lot of cases never make it to trial. They either settle before they get there, or in many cases, they're resolved by a dispositive motion. In many cases, summary judgment is involved. The parties get to the point after conducting discovery that they conclude there's no genuine issue of material fact. And one of them files a motion for summary judgment. When there's a close case, or an arguably close case on a Rule 56 motion, do you have any opinion on what's worse, granting a meritorious dispositive motion under Rule 56, or failing to grant one that is meritorious?
Well, Senator, I appreciate the question, and I'm certainly cognizant of the dilemma that you have posed there. And I can tell you that I find no virtue in either option that you've given me. I have litigated summary judgment motions as a lawyer. I have ruled on them as a judge. And it is my intention in all of those circumstances to get it right. It is not my inclination to take the easy way out. And getting it right on summary judgment is a heavy lift.
Right.
But I study the issues carefully, and I'm aware that some believe that having one's day in court is the automatic out in a close case.
And
But there's
what do you mean by that when you say having one's day in court?
Meaning denying the motion for summary judgment.
And thus allowing the case to proceed to trial?
Correct. If you deny the motion for summary judgment, the case proceeds. I think some believe it will likely settle, and so that's the safer option.
So is that what you referred to a minute ago when you said the easy way out?
Correct.
Because it's easier to deny the motion for summary judgment than to grant. Why is that?
Well, because it takes a lot of heavy lifting to carefully review the filings and to write the significant order in support of a granting of a motion for summary judgment.
So that's more likely to involve an opinion rather than just a simple order saying there's...
Correct.
Yeah.
And judges with busy dockets, I think everyone wants to get it right, of course, but judges with busy dockets may err on the side of caution and say, let me deny the motion. That's a quick, just a really quick order. But I believe that the more courageous approach is to carefully consider those issues and really to make the ruling that is demanded by the law and the facts. And were I to be so fortunate as to be confirmed into this role, I would continue to my commitment to not taking the easy way out and to making the brave decision in whichever manner the law and the facts support, and then standing behind that, whatever comes.
So if I understand you correctly, neither one is more defensible than the other. They're both bad. They're both equally indefensible.
Yes,
the
absolutely.
temptation is greater to deny the dispositive motion.
In my experience, that is absolutely the case, Senator.
And so, in other words, the judge needs to look out for that temptation among judges, because if you do that, the case may well settle long before it gets to trial.
Correct.
By the way, what tends to take more time, your average criminal case or your average civil case, or is there a difference?
In the judicial or in the lawyering context?
In the judicial context.
In my experience, civil cases have more nuances, more heavy lifting in terms of the handling of those matters. Certainly all are important, and I give full attention to all matters before me, but they usually have the more dense subject matter in terms of preparation.
Right. Some of that probably relates to the prevalence of the dispositive motion in civil litigation. Not as much of that. You have other kinds of motions.
Certainly.
Trial.
Certainly.
All right. I see my time's expired. Thank you. I was hoping you could confirm the Wallflower thing, but, worth a shot. Thank you, Mr. Chairman. Thanks to all of you for being here and for your willingness to serve. Judge Bulsara, I'd like to start with you. There's an organization that you belong to called the National Asian Pacific American Bar Association. You've been a member of it for the last 7 years. It's abbreviated sometimes as NAPABA. NAPABA has made a number of comments over the years, and I understand that someone can belong to an organization without necessarily embracing every statement that organization makes. Nonetheless, there are some of these statements that I'd like to know, I think others on the committee would like to know, whether you agree with them. Among other things, NAPABA has publicly taken the position, quite aggressively, that no sanctuary jurisdiction, that is a city, municipality, or local unit of government, may be denied federal funds or may have any federal funds withheld on the basis of that entity declining to cooperate with federal immigration law enforcement authorities. And so they take this opposition to any legislation that would withhold any federal funds to sanctuary cities. Even worse than that, NAPABA goes a second step and states that it believes that states and localities that decide to be sanctuary jurisdictions, that is, that don't honor ICE detainer requests, deserve, in fact, to be rewarded with additional financial support. Now, do you share this view that sanctuary cities ought to be rewarded and never have federal funds withheld for refusing to cooperate with federal law enforcement?
Thank you, Senator. I think, as you may appreciate, NAPABA has several 100,000 members.
Sure.
I'm only one of those members. I'm not an officer director. I'm certainly not familiar with the class of statements that you're addressing or any press releases to that effect, and I've never read any NAPABA statement on these particular items that you've identified, so I can't...
So you were not aware they had taken this position?
I was not, Senator.
Do you agree with that position that they've taken?
Senator, I can't agree or disagree with the position because the issues you've identified, not only do they come up in our courts, they're likely to come up in my court.
Actually, I'd push back on that. This is a legislative determination. This is almost impossible that it could come up in your court. And keep in mind, this is a core function of the federal government. It is only the federal government, under Article 1, Section 8, that has the authority over our immigration laws and consequently over the enforcement of those laws. This is the prerogative of the federal government. And yet you're saying that a local jurisdiction that refuses to cooperate with that should not have federal funds withheld, or the entity is saying that rather. Now, a legislative determination, again, I don't think this is something that could or would come up. But let's move on. NAPABA has also opposed legislation, H.R. 734, the Protection of Women and Girls in Sports Act of 2023. Do you believe that males should compete against females in sports?
Again, Senator Lee, I can't comment one way or another about that topic, in part because in Long Island, just as an example, there are states and there are local and county legislation that's been passed in the recent weeks. Those laws are under challenge. Those cases are being brought in the Eastern District of New York. I simply cannot comment about issues that bear on litigation that are before me.
I understand that you're declining to answer. Keep in mind, you are a member of an entity that has made those statements. And if you can't comment on those statements, then perhaps, as a judge and as someone sitting for a nomination to be a lifetime appointed federal judge, then perhaps the answer should be that you shouldn't be a member of the organization. But it does raise an inference as to whether you do agree with them, and I note for the record that you're declining to do that. Now, NAPABA filed an amicus brief in a case called Students for Fair Admissions versus Harvard. I'm sure you're familiar with that case. It went before the Supreme Court and was decided about a year ago. And in that brief, it called for, quote, consideration of race as a factor in college admissions. Do you believe that some students should either lose or have lower access to educational opportunities in higher education based on their race?
Well, I think, Senator, the Supreme Court has clearly said no. And it's my current oath, and if I'm...
You'll stick with that.
And I...
Now, NAPABA also called the Supreme Court's ruling in another case, 303 Creative versus Elenis. It called it misguided. Do you also believe that that decision was misguided? Do you share this view? And how should the case have been decided if it, in fact, were misguided?
Senator, I'm not familiar with that statement, but I never refer to Supreme Court decisions in that way because of my oath to follow them, and it would be inappropriate for me to disparage decisions and then uphold my oath to follow them.
Okay. My time's expired. Thank you, Mr. Chairman. I do note here, look, if you're going to belong to an organization that engages in advocacy, you can't have it both ways. You can't at once say, I know nothing about that, and then decline to say anything about it and belong to that organization. I think you ought to have to answer the question. Thank you. Thank you, Mr. Chairman. Thank you, Judge Maldonado, for being here. When we look at the work of a federal district judge, it's a busy docket. One has a lot of motions to follow and to stay on top of. Some of the motions that end up taking a lot of time are on the civil docket side of things, motions for summary judgment. In your view, is it, what's worse, to, when you've got a close case, to grant a non-meritorious dispositive motion or a Rule 56 summary judgment motion, or to fail to grant a motion for summary judgment where it is warranted? In a close case, which one is worse, or is either worse?
Thank you, Senator Lee. So I am very careful with motions for summary judgment because I respect the role of the jury. And I think it is rather arrogant for me to decide there's no disputed issue of material fact. And so I inherited, I don't know, tens and tens of motions for summary judgment, and I take those very seriously because I don't want to take someone's day in court away from them and usurp the role of the jury. Sure. So those are the most time-consuming motions that I have before me. And just to clarify, when I received my reassignment, many motions that I received were from 2020, 2021, and so I had to triage and have a pipeline and decide the oldest first, and that was sort of my plan of attack, to decide those older motions first.
Okay, that's helpful to know. So it sounds like you may have gotten assigned some dogs when you arrived. It happens sometimes with the newly arrived judge. It's sort of a hazing ritual among some judges. Well, the reason I ask about the dispositive motion issue is that there's a natural tendency among judges, including federal district judges, to want to not face the more difficult decision whenever they can avoid it. It is more difficult to grant a motion for summary judgment than it is to deny one. And you're subject to appeal much more quickly, more likely to get reversed, and if you deny it, the parties might well settle and call that trial by attrition. It's a list of paradoxes that exist in the court, in the judicial system. On the one hand, justice delayed is justice denied. On the other hand, as evidenced by the turtles on display in the courtyards at the Supreme Court across the street, sometimes the deliberative process needs to be deliberate and it needs to be slow-paced. And so those tensions have to be managed. But the risk we run into is the judge looking for ways, perhaps, to minimize the judge's exposure to being overturned on appeal and the workload. Granting the motion for summary judgment requires you to write an opinion or order, which takes time and can be immediately appealed. Now, of these cases that you've got, I think it's 125 pending motions that you've got, ranking you as number one in the Seventh Circuit, number 7 in the nation. There are some that are troubling, some that, including one that was filed by a prisoner. This is not complex multi-district litigation involving huge mega corporations. There's one, for example, that's been fully briefed since November 2021, for 3.5 years nearly. We call this a fully ripe motion for summary judgment. The prisoner in this case filed the case complaining that he's, while in prison, suffering extreme tooth pain. It's apparently going unaddressed while he's in prison. They've done everything they can to get it teed up. It's fully briefed, it's before you, and just last month the plaintiff submitted another status report request of the court, and your response was, quote, "The court has taken defendant's motions under advisement and will endeavor to rule on both in the near future." What does that mean here, endeavor to rule? And what more would you need to rule on a case of that relative simplicity in less than 3.5 years?
Thank you, Senator. So do you happen to know the name of that case?
We can get that for you.
Okay. So there is a triage process that I follow in my chambers. We're generally working on the oldest motions, and I think reading what you just wrote, listening to what you just read to me, I think this means it's in the immediate pipeline, meaning that it's in the top, 10 things that are immediately going to be issued. Now, I am a very involved judge. I edit every single thing that goes out of my chambers, and so oftentimes and I go back and forth with my law clerks on drafts. It's not sometimes the most rapid process,
But does this case ring a bell? Do you recognize?
If I knew the name, it's probably with all my law clerks, we have our list of things that we're working on, our pipeline, which has to be based somewhat on chronology. So you mentioned November 2021. I wasn't even on the bench yet. And so that came to me almost a year old.
Right.
And that wasn't even one of the oldest.
It was fully ripe before you became a judge. And
a year before I became a judge.
And I understand that sometimes new judges, part of this hazing ritual that I described, get assigned dogs, get assigned a long list of cases with pending dispositive motions. I understand that happens. But we will get that information to you. I raise it simply because it is very important that we not drag those out. At some point, it becomes trial by attrition, and the parties lose a lot when justice is delayed. Thank you, Mr. Chairman. Thank you, Mr. Chairman. Thanks, Mr. Ritz, for standing for this nomination and for being here today. Now, it's my understanding that you were subject to an ethics investigation by OPR. Is that right?
Never in my career.
Never. But you're aware of this situation in United States versus Von Rico Weber, where you were accused of making these material representations to a defendant's attorney in order to elicit a guilty plea.
I have some recollection of that, Senator, but I was not subject to any sort of formal complaint or investigation.
Okay. Well, it's my understanding that in this circumstance, this would have resulted in the defendant serving a 10-year prison sentence, and the accusation is that you led the defendant to believe that a low sentence, a much lower sentence, would be in order, or perhaps even probation. I just want to read to you the letter, the email that we received from the concerned defense attorney, shining light on the incident. The person writing this email is recounting a conversation with the defense attorney in which you allegedly misled the defense attorney and the defendant. After the defense attorney explains it, here's how he explains it. At this point, I stopped the conversation and said, "Was the AUSA Kevin Ritz?" The answer was yes. It is unfortunate that this is not the first, second, third, or whatever occasion that this sort of thing has occurred, but everyone should be aware of this unfortunate pattern of behavior. You should be aware, your clients should be aware, and you should proceed with extreme caution. It is a sad commentary. This is a concerning allegation, of course. Now, I assume that you would agree, certainly, that misleading a criminal defense counsel as to the nature of the charges against the defendant and the likely sentence that might result from a guilty plea that would violate a federal prosecutor's ethical responsibilities.
Yes, and I did not do that in that case, Senator.
Now, my understanding is that a complaint was made against you with the Department of Justice Office of Professional Responsibility and that an investigation ensued. At what point did you become aware of that investigation?
Again, Senator, to my knowledge, there was never an OPR investigation or a complaint for that matter.
Okay, so you're not aware of anything like that?
That's correct.
Does the information you just heard, the accusation, does that reflect your pattern of behavior as a prosecutor?
Absolutely not. And I recall this, and I recall that the person who had sent that email communication certainly had not communicated with me. I'm not actually sure we had ever had cases together in the first place. In any event, I took action, and I believe I communicated with everyone who received that, because in our federal district, it's really important for AUSAs and defense attorneys to be able to trust each other. And sure. I took my reputation very seriously.
Okay, but you would agree that if you had done those things, that had resulted in a complaint to OPR and you didn't disclose it, either of those things would be a problem?
If I had acted unethically, absolutely, but I did not.
Now, as you know, one of the most important decisions a U.S. attorney can make is the decision about whom to hire as a first assistant U.S. attorney. Would you agree with that?
Yes.
It's a pretty important thing. And it's why I find it disturbing that you chose to hire Ms. Reagan Taylor Fondren to serve as your first assistant, despite the 2 disciplinary investigations that she was under for serious accusations relating to ethics violations. As a former federal prosecutor myself, I know that the fairness of the justice system depends a lot on, among other things, how prosecutors handle things like exculpatory evidence. And withholding exculpatory evidence from defense is a big problem. Ever since Brady versus Maryland was decided in 1963, every prosecutor knows that there is an obligation to disclose these things. Now, when you chose Ms. Taylor-Fondren to be your first assistant, were you aware of the two ongoing investigations of her alleged prosecutorial misconduct related to failure to disclose exculpatory evidence?
I may have been aware of ongoing proceedings. My recollection, Senator, they were not. They were still proceeding, and I honestly can't remember if they still are today.
So they were pending at the time you chose her. Were you not concerned about that?
Senator, I am not sure I knew the particulars of the situation.
In fact, she began your service as a first assistant before her court-ordered suspension from legal practice was enforced. Is that right?
I believe that's correct, Senator. I'm not actually entirely sure.
Now, a man served 4 additional years in prison because of the misconduct of your first assistant. Now, thankfully, the Court of Appeals corrected her error, but not for the full 4 years. And so, was it in spite of or because of Ms. Taylor-Fondren's willingness to violate the defendant's constitutional rights that you chose her to be your first assistant?
Senator, as I said before, I believe that Ms. Fondren and all of our AUSAs are doing an excellent job keeping people safe in West Tennessee. These allegations and this incident occurred, I want to make clear, before Ms. Fondren was part of our office several years ago.
But you were aware of the accusations?
I was aware in a very vague sense.
Thank you, Mr. Chairman. I want to follow up with Judge Nett Byrne regarding the JJS case. I've been reading through your report and recommendation, and I just want to review the fact that this was an individual, JJS, who had raped a 9-year-old boy, raped a 17-year-old girl, was put in prison, went to prison for a long time. After that person was paroled, JJS, the way you put it on page 44 of the report and recommendation was that that JJS sent 2 sexually explicit images of minors in 2015 while out on parole. I should point out this is kind of a euphemistic reference. These were not just sexually explicit images. These were sexually explicit images of adults violently molesting children, sexually assaulting, abusing children violently. Every time this person has had an opportunity to offend, this person has offended. And yet you recommended this person against the recommendation of the U.S. Bureau of Prisons to go to a women's facility. Now, your reasoning here is stunning to me. Going back again to page 44 of your report and recommendation, you say, quote, "There are no signs that petitioner is at risk of reoffending." I'm struggling to understand how you could possibly conclude that, because the minute this person was released, this person engaged in other offenses. Yes, not a contact offense while out on parole, but there are still issues going on. It says nothing. You don't adequately grapple with the obvious fact that this is a 6'2" biological male. Yes, transition aside, the transition didn't begin until age 51 or 52. By then, JJS had acquired all of the physical, biological size and strength advantages of being male. Those don't go away because there is a transition. On what planet does it make sense? On what planet does that person with that sexual offense history, with being biologically male and also 6'2", not pose a threat to the safety of female inmates? I don't understand how you could conclude that this person shows no risk of being an offender. Now, you argue at one point that this person has shown no pattern or history of offending while in prison. Yeah, because JJS was in prison with a bunch of other men where the size and strength differentials aren't quite the same. Can you help me understand this?
Thank you, Senator. First, the crimes for which the petitioner was convicted are horrific. I've been a sitting United States magistrate judge for 12 years. Sexual offenses against children are among the worst crimes that we see. This person was convicted by guilty plea 30 years ago of 2 awful crimes and was sentenced to a very significant prison sentence by the state court judge. About 8 years ago, the petitioner committed another awful crime, the crime of distribution of child pornography. That is an abhorrent crime, and there are real victims. And the petitioner was sentenced by the Indiana federal court.
I understand this. This is all undisputed. What I want to know is, why is it okay? Why is it safe? Why is it fair to female inmates to send this person to a female prison? This is a guy who raped a 17-year-old girl and a 9-year-old boy. Why is that safe? 6'2" biological male.
Senator Lee, as I do in every case before me, I look at the record evidence. I consider the facts before me. In this case, the facts that I considered included that every single warden who supervised this petitioner recommended that the petitioner be transferred to a women's facility because of her serious medical needs, because she had engaged in no violence, no infractions, and in fact had been the victim of sexual assault.
While in a male prison, and this was against the decision of the U.S. Bureau of Prisons. Judge Valenzuela Dixon, do photo ID laws violate the U.S. Constitution? Does it violate the U.S. Constitution to require someone to show identification when casting a vote? Does it violate the U.S. Constitution? Is it unconstitutional?
Please turn on your microphone.
Thank you.
I asked because you submitted a brief in a case called Crawford versus Marion County Election Board. And in your brief, you argued, quote, the striking similarities between voter identification laws and poll taxes this court rejected less than a half century ago demonstrate that identification requirements are unconstitutional regardless of the level of scrutiny the court applies. The court, of course, disagreed with your assessment.
It did.
So what's your answer to my question?
The Crawford case made it clear that voter identification laws are constitutional, and I would follow that precedent.
Do you agree with that precedent?
That photo ID laws are constitutional?
Yes.
I do, Senator.
And yet you argued to the contrary in that case. Did the court convince you?
Well, the court stated what the law is, so I would follow the precedent of the Supreme Court.
Thank you. Thank you, Mr. Chairman. Thank you, Mr. Chairman. It's an important day. Anytime we're considering judicial nominees, it's an important day for America. It's important to have independence within our judicial system. We talk about this all the time, and it can't be repeated too often, but I think that needs to be repeated today. Today, especially as we look at what has happened with the political weaponization of our judicial system. We've got a sitting president whose party has indicted, whose party has now secured the conviction of his only impediment toward being elected for a second term. This has never happened in our country, and I hope it will never happen again in our country, but it's something that we've got to watch out for. Something that sends a strong signal of a lack of judicial independence. This coupled with a lot of irregularities from the judge, irregularities from the way that we've got prominent Justice Department official who went to assist with the prosecution. We've got 3 members of a prominent law firm, the Paul Weiss firm in New York City, high-paid lawyers who were given paid leaves of absence to go and assist in the prosecution. We've got to be concerned about this. And so as we obsess one day about flags flown outside the home of a Supreme Court justice, we would be doing ourselves and the judicial system a grave disservice by ignoring the fact that something very significant just happened. And it's concerning. But look, if we want judicial independence, this is a good time to focus on it. And I hope to do that in this hearing as in all others. Thank you. Thank you, Mr. Chairman. Judge Kidd, do you believe that rape laws are laden with racial baggage?
Senator, I have never made that statement, and as a former prosecutor, I prosecuted individuals who had committed crimes against children and other sexually violent crimes.
Okay. The reason I raised the question is that you're cited in the acknowledgments, very early in the acknowledgments, in a law review article written by Monica Bell, in which she thanks you for conversations that shaped the article. In this article, she makes a number of claims, including the suggestion repeatedly that rape laws, child rape laws, including rape laws generally as well, are laden with racial baggage. She also makes the case that the image of the child molester or the rapist is often disproportionately or unfairly leveled, this sort of racial dog whistle, and makes a lot of these cases after thanking you for conversations that shaped it. Are you saying you disagree with her characterization of the law in that respect?
Senator, I think I recall the article that you're talking about, and I believe that Monica Bell, who's my law school classmate, wrote that article while we were in law school, and I certainly have not made any statements, and I don't recall making any statements to now Professor Bell regarding any rape laws, so I do not adopt anything that she has stated. I'm certain we had conversations generally in law school. I don't recall what they were about, but I certainly do not recall any conversations about rape laws.
Do you share those views that she expressed?
Senator, as best as I can recall your summary, I do not share the views. I would certainly follow whatever laws are in place with regard to rape and whatever issue happens to be at issue.
All right. In the same article, she also stated, quote, when a law threatens to impinge on constitutional rights, and especially where those at risk are those whom society would most like to cast out or even exterminate, courts must understand and evaluate the social forces that motivated these laws. Today, child molestation sparks the same urge for community isolation and the spirit of vigilantism that rape did in the Coker era. An analysis of the multi-layered political context of capital child rape laws suggests that the social forces surrounding the new legislation are inescapably too intense, too frenzied, too emotional, and too mired in racial and class-based prejudice to avoid arbitrariness and caprice. Now, I'm not quite sure what she means by laws that implicate constitutional rights. In a sense, all criminal laws do that, in that they will restrain your liberty if you violate them and you're found guilty. She's arguing, in essence, that evaluating criminal statutes that implicate constitutional rights in one way or another, that in doing that, courts have to understand and evaluate these social forces that animate whatever it is that prompted the enactment of the legislation to begin with. Do you agree with that statement? And what bearing should that have? When and under what circumstances is it appropriate for a federal judge to consider what forces animated the enactment of a statute, for example, prohibiting rape?
Senator, I do not agree with that statement. As a sitting judge, and if I'm confirmed to the 11th Circuit, I would follow the law, and I would follow Supreme Court precedent, the 11th Circuit precedent. It's not my job as a judge to assess societal forces. That's left to the policymakers, not to me.
Are there any circumstances under which the social forces that motivated the enactment of a statute under consideration by the court should be taken into account? If so, what would those circumstances be?
Senator, I know that there are certain circumstances, for instance, with religious liberty, where if there is a law in terms of assessing whether it's actually generally applicable and neutral, the courts can look to certain circumstances surrounding its enactment. But as a general matter, no senator would not look outside of the plain text of the law.
So outside the narrow context of the city of Hialeah versus Church of the Lukumi Babaluai, you would say you typically would not do that as a federal judge?
That's correct.
Great. Thank you.